Harmeet, good to see you. Thanks for joining us.
Thanks for having me, Sean.
You bet. I want to start our conversation by talking about what's going on in Texas. There's a lot of talk about redistricting, and it happens. This is politics. People redraw lines, whether you like it or not. But the Democrats are now looking at what they've done for years past when they control legislatures and redistricting, congressional districts, and somehow saying what Republicans are doing in Texas is undermining people's civil rights. Do they have a leg to stand on this, or is that just a talking point?
Well, Sean, I actually kicked off this whole situation because the Civil Rights Division of the Department of Justice is responsible for administering the Voting Rights Act, as well as two other federal civil rights statutes involving voting and some others actually beyond that. And I did an analysis of what was happening there in Texas with some racially drawn districts and determined that because of the way that they had been composed based on outdated law, that they were actually in violation of the Voting Rights Act. And I sent a letter to that effect to Governor Abbott and to AG Paxton. And so the calling of the legislative session about this is actually triggered by a Department of Justice finding that certain districts in Texas were illegal under the Voting Rights Act. And they're going to see that is going to be the kind of the hot button issue, because for decades, Democrats particularly have really relied on racial gerrymandering, using the Voting Rights Act arguments that are now no longer in vogue to draw these districts that basically carve out protected districts for candidates that usually are Democrats. And so if that's at an end nationally, and that, there's a United States Supreme Court has just agreed to take up a case that may even broaden the application of those rules, it is absolutely a crisis situation for people who've relied on racial gerrymandering. And so, I think that's what you're really seeing unfold here is the stakes are very high for people who have casually relied on race for their elections to be won.
There's in Louisiana, they have these majority minority districts, which means for the casual viewer that they drew a district to basically create a black district, right? And that was the idea. And you look, and it's always been fascinating to me to look at the difference between districts that are represented by black Republicans versus black Democrats, right? So, for example, a lot of Democrats are in districts that are majority minority. They drew the district to create something that could be represented in theory by a black American, an African American. In Republican cases, I think Byron Donalds or Burgess Owens, they're just representing a district. It's not. It wasn't. They were the candidate that ran, made a case, and won. And so you look at a case like what Louisiana's done, where they've literally created congressional districts under the guise of race to say we want a black American. So why is it when you draw a district to benefit a black American, they so-called underrepresented groups, right? Why is it that race is that factor? Is that because of the law that somehow that's legally allowed?
Well, because I'm going to be involved in litigation, probably involving these issues, I'll be a little circumspect here. But, I came from California, where there are 52 members of Congress, and a lot of them are also beneficiaries of this racial gerrymandering. And so you're correct. The concept stems from a history of discrimination in our country. And what I want to say is today it's 2025. That history is far in the past. And in fact, in recent precedents in the last decade or 12 years or so, United States Supreme Court has observed that these sort of penalties that are imposed, or these restrictions that are imposed on certain states that may have a history of racial discrimination, they can't continue forever. There has to be a refreshing, if you will, hitting refresh and understanding, is there still ongoing discrimination that prevents particular people from a particular background from having a fair chance at being elected, or those communities having a fair chance at being represented? But, stepping back, you have to, the whole concept of this racial gerrymandering relies on, which I think is a very outdated premise and frankly never was appropriate, that someone has to look like you to represent you accurately. If that were the case, Sean, I would not be sitting here in this chair, because when I went to law school, there were no people like me. There were no mentors like me. And yet somehow I managed to succeed despite that. And so I think the point is, in America, we believe in equality of opportunity and egalitarianism. And I don't feel like the representative needs to look like me to represent me fairly. And I think more people need to around to that fact that in 2025, just about anybody has a fair chance here in the United States.
I'm being serious when I ask this question because I'm not a lawyer. But like I'm 5'6", so I could argue that in order to represent me, I want people to understand what it's like to be short. And so is what I'm asking you in all seriousness is what when Democrats gerrymander and they use race as the deciding factor and they talk about underrepresented populations, which you just alluded to, is that something that's based in law where they can say because the Civil Rights Act or the Voting Rights Act allows race to be the factor? Because to your point, like if we play this out, right, I go, okay, I'm of Irish descent, working class family, and I'm 5'6". So I want someone who looks like me to represent me. That's silly. And so my question is, when the Democrats do this, is it a political argument or a legal argument?
Well, it is a legal argument that has in part been struck down by the United States Supreme Court. And so there was sort of a permanent penalty box for certain states that had a history of racial discrimination. And to be clear, all the characteristics you mentioned are not necessarily protected by law. Your height, for example, or even for voting purposes, your Irish ancestry. But we have had a history. I don't want to downplay it. There has been a history in the United States. It dates back to the founding where, African Americans were not considered equal and they didn't have freedom. They didn't even count for purposes of, the population. And that law has changed. And thanks to enlightened laws, thanks to changes in our country, thanks to, the Civil War and a lot of laws that followed, which I'm responsible for administering, our situation in America has changed radically. And yet we are stuck with outdated concepts of racial gerrymandering that are inconsistent with how we live in America today in 2025. And so we need to acknowledge that reality. And the court has partially addressed that. And I think you're going to see in this Louisiana case, it's going to be a watershed case for how we administer our elections, draw those lines. And I hope it yields in a concept of more colorblindness, because you see some Democrat politicians online, Jasmine Crockett and people like that, panicking because their safe seat that's been drawn for them may have to compete with everyone to get elected. And that's a reality for people on one side of the fence. The Republicans are typically having to compete with everybody. And so those rules may change based on that Supreme Court precedent.
Okay, so one last thing on this, then I want to move on. But again, as a non-lawyer, just from the outside looking out, I would look at the Republican side, going back to Gary Franks in Connecticut's 5th District in the 1990s, to Burgess Owens in Utah today, to Byron Donalds in Florida today, and say, okay, you have black politicians, regardless of party, that are winning in non-minority districts. They made the best case. They won a primary, then they won an election. Why, so clearly people of color can win in non-minority Democrat-drawn districts, right? To your point, Jasmine Crockett's district and many of these folks are literally drawn for them as opposed to make it equal. So as a lawyer, again, I don't want to make you give away your case, but wouldn't it just be like holding up, even current members of Congress, Byron Donalds, Burgess Owens, et cetera, and saying, okay, if their argument holds water, then how do these other people get elected in non-minority districts?
Well, you're not a lawyer, Sean, but you're playing one on TV, because these are going to be arguments that are made in that Louisiana case for sure, that empirically, setting aside the law, just the empirical data does not support the continued racial gerrymandering that has become habitual and even, according to lawmakers, required. And so, that kind of kicked off our letter. Was the concepts are really outdated even under current Supreme Court precedent. Now, the court may go further and ban this practice altogether, and that is going to be a sea change in competitiveness of districts. And for everyone, to be clear, the flip side of racial gerrymandering is, frankly, some would argue, more safety in the adjoining districts where people have a different racial background. And so everyone's going to have to compete for everybody's vote, which seems pretty American and pretty a good idea to me, but it is going to be a change for all federal politicians in the congressional, I should say, congressional politicians.
All right. Well, speaking of voting and competing for votes, you guys have really led the way in championing an effort that I think is music to a lot of people's ears, not just people on the right, cleaning up these voter rolls. You've made it a priority at the Department of Justice to clean up voter rolls, purging duplicate voters, non-citizens. Walk us through what that effort looks like in your office.
Well, the Help America Vote Act and National Voter Registration Act are two statutes that provide for easy voter registration, and they also require states to maintain clean and updated voter rolls. Now, many states, including my former home state of California, were habitually out of compliance with these rules. They couldn't get their technology to work, ironically, and things like that, or that was the excuse. And some states, some frankly Democrat elected officials have been resistant to updating the voter rolls regularly. So you see some states like Georgia. Georgia passed a law a few years ago after the 2020 election that has a really modern, up-to-date method for cleaning up the voter rolls. If someone hasn't voted in successive elections and a federal election, they get a postcard, and if they don't respond by, saying, yes, keep me on the voter rolls, they get removed. This is a healthy thing to do because just to give one example, Los Angeles County alone in a 2017 lawsuit found that there were over 1 million people on the voter rolls in that county, the most populous county in the United States, who are dead, had moved, or duplicates or whatever. That is very sloppy. And that fact undermines the confidence of the voting public in the outcome of our elections. It also enables fraud. I don't have to prove that there's fraud. The fact that there is a possibility of that really undermines confidence. And Congress has decided that states are supposed to have clean voter rolls. So many states are out of compliance with these rules. They don't have a method for challenging things or getting off the rolls or what have you. They don't have any method for cleaning up the rolls. So we've actually sued in 2 cases so far in North Carolina, as well as in Orange County, because in the case of Orange County, they simply refused to give us the evidence needed. And this is after there were credible reports of non-citizens being on the voter rolls. But it doesn't have to be illegal aliens or non-citizens. Even citizens who are on the voter rolls, but they actually moved to another state or some other reason, that's illegal under these federal statutes. And so we're just doing housekeeping here. It's not very sexy. It's, kind of tedious, place by place, state by state, county by county, where we're doing the work needed. And it's a Herculean task because it hasn't been done ever, I think.
It's funny you say that because there's a difference between, well, let me ask, I'll give you a personal example. So I moved after I graduated from high school and then college. I moved around the country during campaigns. I settled in Virginia in the late 90s, registered to vote here, in Virginia. And my understanding, as far as the law, is that when you register, you tell them where you were. They send a note and say, hey, Sean Spicer is now living in Virginia. He's registered to vote here. So, for example, in the state of Rhode Island, you guys, please take him off the voter rolls. When I was in the White House, they did a report and they said Spicer's still registered in Rhode Island. Of course, I hadn't voted twice ever. I voted solely in Virginia from the late 90s on. And so there's a difference between that sloppiness that the state of Rhode Island, which doesn't surprise me because of how it's run, handled its voting rolls, than fraud. In your mind, Democrats, here's what I'm trying to get at, though. Why wouldn't you clean up your voter rolls unless you had, is it just laziness, or do you have ulterior motives in a lot of these states?
Well, I'm not going to ascribe motives, and, that would be inappropriate, but it is at a minimum sloppiness. And that sloppiness allows and enables fraud. And so in your case, in your, Rhode Island example, your ballot wasn't voted. But there have been cases that have been reported of people who moved and their ballots being voted. I've been a volunteer election lawyer and a official election lawyer for multiple campaigns and for the California Republican Party. And when there was a recall election of Gavin Newsom in a few years ago, there were individuals who I knew who got ballots mailed to them in their next state. Not that they forwarded the mail, but literally the state of California, the county that these people lived in, mail them a ballot ab initio to where they lived in Tennessee or some other state, okay, which is insane. And then, sometimes people would go to vote, they'd be moved from one county to the other, and someone had voted their ballot. That also happens. That is fraud. That kind of fraud does happen. It doesn't have to be numerous, but what it does is it actually discourages people from voting because they feel like my vote's not going to count because of these examples I see out there. So I think it is a problem. And you would think it would be pretty easy in the electronic age where all these companies know exactly, you're thinking about something and then an ad pops up. Yet the inefficiency of our government systems is such that there's no desire on the part of these officials who are secretaries of state and for many cases to do anything. First of all, they don't want to be Secretary of State. They want to be governor. They want to be senator. Nobody wants to be Secretary of State. Pretty few people want to be Secretary of State. That's the reality. And so they're not interested in doing a great job. They're interested in biding their time, going to fundraisers, and preparing themselves for the next thing they really want to run for. That's a problem here. And so we should be able to fix this with enough determination and lawsuits and funding. And I hope we're able to do that.
I do too. The White House tweeted out a great story that says for the first time in 40 years, the federal government can judge applicants by merit. In other words, we're rooting out DEI. That's been something that you've been leading the way on. Walk us through both what had been the case and then how it's going to work going forward.
Well, there was this Carter era lawsuit involving civil service requirements. And, to cut a long story short, there was a consent decree issued in that case, a case called Luovano, that required, DEI. The DEI wasn't even called DEI back then. It was sort of called affirmative action in the government civil service hiring. That policy is inconsistent with current federal law, including the president's executive orders. And so we got rid of it. We dismissed that consent decree last week. And it is going to open up open competition for civil service positions that hasn't existed since the 1970s, if you can believe that. And so, 1980s, I should say, but the lawsuit started in the 70s. And so it is a long overdue that we get rid of that and we usher in this era of open competition for all, because what we've had with DEI, which, I think is discrimination, exclusion, and in some cases incompetence, and intolerance, is not a level playing field. And people who are qualified because of their circumstances of birth have been excluded from opportunities. We are focused in the DOJ in rooting that out everywhere we find it in the United States, where federal law applies. In this civil service thing is the most obvious one because it's a federal government hiring. But wherever federal money is being spent with government contracts, government contractors, with education, with even in hiring, we are getting rid of it wherever we can. And it is just a monumental task because it has this discrimination, this legalized discrimination, Sean, has permeated every aspect of our society. You can't get hired as a white man or get tenure in most of America's universities today. And that's illegal, by the way. So we're chipping away at that. As you've seen the Columbia settlement, there are going to be other settlements or lawsuits coming down the pike, and the Civil Rights Division, which I'm heading up here, is the tip of the spear for all of that. But it's everywhere, and it has impacted America's productivity, and we're going to end it.
I'm glad to hear. You've been a champion. So many issues in your office alone. Between this, you were critical in the Cincinnati thing with respect to that mob that attacked a bunch of folks. You were the one who really went in there and made it clear that this was a racial issue and all of the talk. But I want to ask you about one last question because I know your time is tight. And this may sound silly, but it actually matters. Over the weekend, attorney Alan Dershowitz, who has been a defender of the president, not because of his political beliefs, because his steadfast belief in the Constitution, was at apparently some kind of farmer's market in Martha's Vineyard. And the guy who sells pierogies says, I'm not selling you a pierogi because of your support for President Trump and what you've done. Dershowitz, who is no, wilting flower when it comes to standing up for himself, said his civil rights were violated. I know this is silly to some folks, but Harmeet, is this a violation of his civil rights, or do we have a right to choose based on politics? I don't want to sell you a pierogi or a shoe or a cake or what have you.
Well, is it silly? Was it silly when Rosa Parks was denied a seat on the bus, or was it silly when people in the civil rights movement were beaten up or hauled out of a lunch counter for sitting in the wrong place? I don't think it is silly. And that's where the civil rights law that Alan is referring to stems from. And so there are a couple of things you have to look at. I mean, there can be private clubs, for example. Private clubs don't have to serve everybody. But if you're a farmer's market, which is typically on some city property or, run by some government outfit, that's the case in most farmers markets I'm aware of. Yes, you have a obligation to equally serve. In fact, I administer those laws. They're federal laws about public accommodations. And those public accommodation laws, like, you may have seen in the media, we filed a lawsuit against Jerusalem Coffee House in Oakland, California, for refusing to hire visibly Jewish customers. This is the same concept. When you open for business, you can't refuse to serve someone on the basis of certain protected characteristics. Now, I don't know all the facts. I'm just hearing about this for the first time. But if it's based on those protected characteristics, then Alan Dershowitz may have a case.
Okay, I do, just to be clear, though, so he's Jewish. I don't think it was because he was Jewish. I think it's because of his political beliefs, his support for President Trump. Or frankly, I don't think he even supports President Trump. He stands up for the Constitution. His perceived political affiliation. Is
Right.
Political affiliation covered under that law?
Not under federal civil rights law, but all of our states have state civil rights laws that often are more extensive. So, for example, if this incident occurred in California, California has state civil rights laws, the Bain Act and the Unruh Act and some other acts involving public accommodations that do protect political viewpoint in public accommodations. I'm not familiar with the law in Martha's Vineyard. There may be a law that applies there. I think Alan would probably know better than me, but there are state civil rights laws that apply as well. That would not be a situation where the United States Department of Justice would get involved, however, because our federal civil rights laws do not yet extend to that protected characteristic.
Okay. Harmeet Dhillon, thanks for joining us. And beyond that, just on behalf of so many folks, I can't thank you enough for what you and your team is doing to stand up for what's right. You guys are just righting so many wrongs, and it's different. They weaponize the Department of Justice to serve a political interest. You guys are just bringing it back to center. And that's where I think there's a big difference between how we do things and how the left does it. And so just a big thank you for what you're doing and how you're doing it.
Thank you, Sean, for having me. I really appreciate the opportunity to talk about these important issues.
You bet. Well, if you enjoyed this content, make sure to like this video, subscribe, and click the notification bell to get more.